government to administer justice. I'm by the name Robert Benon Jurua. I'm a legal officer in the Rule of Law and Litigation Department. It is my singular honor to welcome you to the ULS House, in which we are going to have an action-packed few hours from now, for which we are going to start with an opening prayer from one of our own, Jude, who is going to help us usher the day into the Lord so as to continue with our agenda items. Thank you so much.
Thank you, Robert. Good morning. Let's humble ourselves and pray. Heavenly Father, we thank you for this day. We thank you for the gift of life. We thank you for the opportunity for us to be here to discuss constitutionalism in this country. Father, we pray that even as we discuss, you will give us insight, you will guide the discussion, and that even as we discuss, we shall bear fruit with everything we are going to discuss tonight. We dedicate this nation into your hands. We pray that as we fight for the rule of law, as we fight for justice, you'll be at the helm of it, because you are the custodian of justice, and you're the one that created the boundaries of Uganda. So we dedicate Uganda into your hands, and we pray that you continue to be the Lord of this country. In Jesus' name we prayed. Amen.
Thank you so much for the prayer. Could we please rise for the national anthem?
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you. May we be seated. Once again, ladies and gentlemen, we'd like to thank you for making time. We'd like to welcome you to the Uganda Law Society, from which we are coming live unto you in regard to our 37th Radical New Bar weekly press and public engagement. We are very honored to have you, and we thank God for thus far that we have come on this 25th day of September 2025. And of course, that also means that God has been faithful to us in all the protection and all the grace that he has given unto us. Would like to thank you. We would also like to appreciate those that are following us online, because as it is normal, we are the Radical New Bar, in which one of our tenets is radical, technological, and we're trying to transform the way in which we communicate. So we are having guests that are online, and we appreciate every individual who has made time to tune in. As it is normally the case, we would like to ensure that you are going to be up on your feet, as well as listening to the intriguing topic that is for the day so far, and that is 30 years of Uganda's constitution, lessons for the future of democracy. We are all aware that the promulgation of the 1995 constitution, which we are all aware of, was a moment in Uganda's political history that we could not do away with, especially given the decades of coups and authoritarian rule and tyranny in which we had been through so much. For those that, of course, are old enough to know, and also for all of us who went to school and studied history, we all have the history of Uganda within our purview. We are aware of the 1966 constitution that was promulgated at the time, and of course the challenges that came there with. We are also aware of the different presidents that have been in power ever since that time, and we are also aware that in 1981 to 1985, the current government, that's the NRA, then took to the bush and insisted on fighting for the rule of law and constitutionalism. And that, of course, was because of what we are also about to go through, a general election that was disputed. Ladies and gentlemen, I don't have to say so much because there is a lot that is going to be said by the discussants and the distinguished invited guests in the house. And our program for today is going to be as follows. We are going to, as we have already had an opening prayer and listened into the national anthem and the East African anthem, we are going to be getting welcome remarks from the representative of the CEO. Because she is on official duty, I must let you know that one of our secretariat staff lost a mother, that is Advocate Sheila Triasingura, and the team, a part of the team, is on the way to Chiruhura for burial. And of course that also meant that we needed to send representation, and one amongst the others that have gone to help and participate in the burial arrangements is the Chief Executive Officer. So she has sent a message that is going to be read unto us, and thereafter we shall be in position to delve into the topic for the day. And I'll repeat: 3 decades of Uganda's constitution, what lessons for the future of democracy. We have lined up 2 distinguished guests who are going to be introduced to the discussion, and we shall hear in from them. The other is not in the house. We are also going to hear from that individual online, and thereafter we shall have a question and answer session, and thereafter we shall be in position to swear in new council members who were recently appointed to the governing council pursuant to section 16.1 of the Uganda Law Society Act, in which members, as you will bear me witness, caused for a general meeting to be held, and last Wednesday we were able to hold that meeting, in which a few resolutions were passed, and one of the resolutions, of course, has been to extend the time of the Uganda Law Society Governing Council in which to organize elections. We shall be hearing from one of the council members in that regard, but what is apparent is that the elections, which I'm aware, you are all aware of, were slated to have been after 1 year of the governing council tenure, which in this case was supposed to be 27th, 28th of September 2025, and given the number of challenges that the governing council has been facing as the Uganda Law Society in as far as court matters and management affairs were concerned, the general meeting, courtesy of the members themselves, resolved unanimously to extend the time within which to organize elections for the governing council, and that time was said to be sufficient in 6 months. Earlier on, you are aware, it was supposed to be 3 months, but we are also very aware of the fact that the Uganda as itself is going to go through general elections, which are scheduled for January, February, and the body, an institution that is meant to organize the elections at the Uganda Law Society, is the same as the body that is organizing the general elections, and that is the Electoral Commission. So, like we said, it was a general consensus that the Electoral Commission be allowed time to organize the general elections for which we are all aware. Nominations were yesterday and they were concluded, and we shall be having 7 aspirants running for the office of the president, as well as so many other members of parliament and councillors, as the general election is yet to start. We therefore have the privilege of having within our presence 2 council members in acting position, that is the acting secretary and the acting council representative from the central within the house, and we shall be graced by a special individual that is going to swear them in, and that is how the program will be. And thereafter we shall have a vote of thanks and closing remarks from the governor of Uganda Law Society. As we begin, we would like to welcome the head of department, rule of law, Ms. Afra Apio, to render unto us the remarks from the chief executive officer. Thank you.
Esteemed guests, Dr. Henry Honoria, Head Law, Consulting and Knowledge Practice, ALP Advocates, Dr. Charles Tolit Atia, Associate Director and Lead Researcher, Center for Constitutional Governance, who is joining us online. Council members present, Mr. Isiko Arthur, Treasurer, Uganda Law Society. Council members joining us online. Incoming council members, Mr. Lule Alexander, Acting Central Region Representative of Uganda Law Society, and Mr. Sali Babu, Acting Secretary of Uganda Law Society. Members of the Uganda Law Society, members of the press, ladies and gentlemen, good morning. My name is Apio Afra, and I'm the head rule of law, and representing the CEO, Ms. Christina Wari, who is away on official duties. One of our colleagues, that is the head lab, Ms. Sheila Triasingura, lost her mother, and Barrio is in Kazo this morning. My chief task this morning is to read her opening remarks verbatim, and I shall proceed to do so. On behalf of the Radical New Bar President, Mr. Isaac Semakade Senior Counsel, I'm delighted to welcome you to the 37th Rnb session live series, a hybrid digital and physical engagement convened every Thursday to foster open dialogue between the Radical New Bar, the press, and the public. This innovative platform is the brainchild of our dynamic Rnb President, Mr. Isaac Semakade, Senior Counsel, and it has grown to become a vibrant press, a vibrant space for legal and civil discourse. The theme for today's Rnb is 3 decades of Uganda's constitution. What lessons for the future of democracy? The Constitution of Uganda, promulgated in 1995, has now been in existence for 30 years, albeit with several amendments. It is widely regarded as a cornerstone of our democracy and a vital safeguard for human rights. Today's engagement comes at a critical juncture when one that calls on each one of us to pause and reflect on what the Constitution has meant in our individual and collective lives. Democracy remains one of the fundamental pillars for the realization of the rule of law in our society. It is against this backdrop that we have invited distinguished guests to share their insights and perspectives on our theme. I particularly encourage the youth to listen keenly and draw from the well of wisdom that will be shared today. In a special way, allow me to congratulate the incoming ULS Council members, Mr. Lule Alexander, Acting Central Region Representative, and Mr. Sali Babu, Acting Secretary, Both will be sworn in today following the successful resolutions of the ULS General Meeting held on 17 September 2025 at Imperial Royal Hotel, Kampala. We wish them the very best as they take up their new responsibilities. As we engage in the discussions ahead, let us remember the rule of law is not the burden of a few, but a shared responsibility. Each one of us has a vital role to play in building a society rooted in peace, democracy, and sustainable development. I thank you all, and I wish you a fruitful and engaging day. Signed, Christina Wari, CEO, Uganda Law Society.
Thank you so much, Ms. Safra Pio, for delivering that message. Madam CEO, we duly received the message. We thank you for your warm regards. We also thank you for standing in the gap and representing us in Chiruhura, and we pray that the Lord will be with you and your team, as well as those that are mourning and joining in the burial arrangements. We want to thank you once again. Ladies and gentlemen, the question of the Constitution is something that should never go unhandled, because we are citizens and the Constitution was meant for us, and it is at this juncture, of course, it is awash on social media about the 30 years that have been on with the Constitution running, and it is the time that we ask questions of how much do you know your Constitution, and yet the Uganda Law Society is here to help you answer these questions. And we are going to begin straight away with the first guest speaker, who has worked in a number of sectors such as media, human rights, and conflict transformation in Africa and Europe in the last 20 years. He is trained in journalism and law. His key milestones are that he participated in the LRA government of Uganda Juba peace talks and the Sierra Leone trials and transitional justice process. As of now, he is an associate director and lead researcher at the Center for Constitutional Governance. Ladies and gentlemen, welcome with me Advocate Tolit Charles Atia, PhD, Governance and Security Studies, who's going to be addressing us online. Thank you so much. We're trying to get hold of him. He was online just recently, and of course, it's also a challenge, as we all know. It's not been an easy ride, but as has been stated by the CEO in her message, we are all aware, and it is in fact the time that we as citizens, especially the young and the majority in the country, get to appreciate that this Constitution was meant for us. And we shall also realize that the greatest achievements, of course, of the Constitution lie in the entrenchment of the rights and freedoms that we are all aware we are now practicing. If you realize, if you've studied history, like I said before, there was never freedom of expression, there was never freedom of association, there was never freedom of the press. As we are seeing, we are joined by NBS and various other media houses. These kind of freedoms were never there. And if you recall, in 1986, as the president, the now president of the country, General Yoweri Kaguta Museveni, was coming in, he laid forth the 10-point program. And we remember the 10-point program was very beautiful, one of the most beautiful visions that you could ever employ. And that alone was sufficient enough to allow that period of time between 1986 to 1990. And then the RCs, that's the Resistance Councils, were eventually formulated. And that, of course, led into the establishment of the Constituent Delegates Assembly, in which we are all aware, and if you remember, we had a lot of dialogue from the public, and the country was led into having consultations from different individuals who, of course, we are going to be hearing about by virtue of one of our guest speakers here. We shall be given that history. But of course, if you realize the Constitution brought forth such freedoms, and we cannot take that for granted, because now we're able to speak, we're able to live, we're able to move up and about. But the purpose of this discussion is not just to appreciate the achievements. We are actually aware that the Constitution and the different rights that we have been speaking about have been eroded, and there's a number of challenges in which we want to help as the Uganda Law Society to understand and demystify. We have been informed that our speaker is online, and we are going to straight away get into listening in to Advocate Charles Tolit Atia, doctor, who is ready to speak to us. Doctor?
Yes, thank you very much. Good morning, and I will observe protocol as already stated. I hope I'm fairly clear.
Yes, you're loud and clear, doctor.
Thank you very much. Yeah, I should have joined the team, and just in relation to our subject today, knowing very well that the team is much as important as the people or selected people to preside over. I learned that just next to the bridge and fell outside the bridge, and therefore held traffic for quite some time. So I couldn't make it. And I think that is the story of Uganda or Uganda's constitution. I would like to say that I am speaking here representing Dr. Sarah Birete, who is our executive director at the Center of Constitutional Governance. Sarah would have loved to be here herself. She's away on official duty, and I have gladly stepped in. So what I will do is I will try to make through her notes, and then shortly after, maybe make one or two observations of my own. Marking the 30 years of Uganda's 1995 constitution in this year, 2025, carries deep meaning for the country's democratic journey. It's both a milestone and a mirror reflecting achievements, contradictions, and unfinished promises. Here are the key dimensions. One, a foundational promise of democracy. The 1995 Constitution was born out of the Constitutional Commission, or what is popularly known today as the Adopted Constitution, and the Constituent Assembly debates meant to end the decade of turmoil. It promised multi-party democracy, separation of powers, checks and balances, and respect for fundamental rights. Two, what are the achievements over the 30 years? We've had the Bill of Rights. The Constitution institutionalized a broad set of rights and freedoms, including economic, social, and cultural rights. Independent institutions. There's the creation of the Electoral Commission, the Human Rights Commission, the Inspectorate and judiciary structures, all aimed at safeguarding democracy. Peace and stability. For many Ugandans, it provided a framework that has underpinned relative stability compared to the pre-1995 turbulent years. There is the element of the avenues for civil society in particular, and for me who watched television yesterday, a few days ago, you know the kind of images that televisions were carrying, the pictures in the media, the clearly that this space is a context. The erosion and challenges. There's we
Doctor, we are losing you. Not aware if it is your phone that you're using and if those calls are coming in. Would like to advise that you mute those calls. I've been told that you're using your phone and that might be the challenge, but we are losing you, and as I speak, we don't seem to have hold of you. Can you hear us, Doctor, please?
Yes.
Yeah, we lost you for the last 10 seconds.
Back?
I'm sorry. Please proceed. That is much clearer.
Okay.
Most obliged.
Yeah, so I said the removal of age limits removed in 2017, consolidating long-term incumbents. Centralized power is now what we are seeing. The executive dominates with parliament and independent bodies often constrained. Here I will add, for those who have been around, we know there was the attempt of the Mugisha Muntu and the late RIP Onapito Eklomoit bill seeking separation of powers. That was another lost opportunity in that parliament. Today, we almost see an undoubted fusion of parliament, the state, and I dare add sections of the judiciary. Electoral controversy. We witness frequent disputes, claims of fraud, and misuse of state resources undermine trust in democratic process. Again here, anecdotal evidence points out to the fact that actually if you reviewed, say, the cases that have come court related to political fraud or political contestation, we haven't had a single person jailed in this country for political misconduct. And therefore, it is sort of set a pedestal that gives a sense of, you know, this is business as usual. So you see fraud, you see misuse of state resources. Recently, I saw this stark picture. I hope it was not the use of AI today of a military truck ferrying or carrying all these civilian people clad in the yellow t-shirt. I mean, these are really sad scenes for a country that is striving to consolidate democracy and therefore constitutionalism in a 30 years space. We are witnessing shrinking civic space, clamp down on dissent, media restrictions, and security force violence contradict the Bill of Rights. The other element is the meaning in democratic terms of unfinished projects. The Constitution remains a reference point for justice and rights, but many provisions have been watered down by amendments serving political survival. I'm not surprised that today, with much welcome, we have received the radical bar, and this is the reason we rally behind it. We will have benchmark for reform. It provides legitimacy for reformers, lawyers, and citizens to demand accountability. But the processes, the avenues, have highly been militarized. They have been gated, they have been barricaded. So you find that there's a lot of hopelessness in the quest for these would-be active reformers. Democracy in response, while institutions exist on paper, they are captured by the ruling elite, meaning Uganda operates under constitutional authoritarianism. And this is probably what you seem to see when you cast a dichotomy table with the word to a 1995 constitution on one side and then 2025. What do you see? You basically see constitutional authoritarianism. A general question at this point. After 30 years, a new generation of Ugandans who the constitution reflects their aspirations or require also renewal. This is both a question, academic exercise, but also a question, practical members of the bar. Looking ahead, we should Uganda pursue constitutional restoration, reinstating term limits, strengthening independent institutions, or is a new constitution and all the other lost opportunities. So you would then ask, why did the promise of the 1995 Constitution end in an the people of Primary Garden? What was expected? Citizens should defend.
We apologize for the technical glitch. Doctor, we've lost you again the past 10 seconds. I wonder if you can hear us. We're sorry. Technical? It's from the other side. Yeah, we're sorry about that, ladies and gentlemen. It, of course, is not our making. Doctor is out of the country. He is unable to be with us physically, but digital transformation is surely going to be coming with challenges. We have had a snapshot of what he has been talking to us about, including the history, as we are all aware, like I said before, the beginning of the Constitution and the preamble and the foundation and the reason that it was formed was also on the backdrop of a lot of tyranny, as he has alluded to, and the foundation of democracy and constitution, and there was a constitutional commission that, of course, was termed as the Odoki Commission, who, of course, eventually became the Chief Justice and right now Emeritus. And the origin of the Constitution was also meant to secure a few challenges that were being experienced. Multi-party democracy was introduced. The elections were introduced, of course. The Bill of Rights and Freedoms were introduced. There was an establishment of independent institutions, as well as peace and stability. Of course, that meant that there was a number of achievements, like you're all aware, and the call today from the Uganda Law Society is for every individual that is a citizen of Uganda to appreciate and, if possible, obtain a copy of the Constitution, because this document speaks into your well-being as far as your rights are concerned. We're speaking of independent bodies, institutional frameworks like the Electoral Commission, which is embedded under Article 60 to 80 of the Constitution, and the Constitutional Court, of course, which is where we take matters for interpreting the Constitution under Article 137, as well as the Inspectorate of Government, which was meant and is still meant to check government institutions, provided for under Article 223 to 231. These institutions were created to ensure accountability and good governance. We also noted that there was a decentralization system enshrined under Chapter 11, which gave local governments powers to manage their affairs, which was a notable shift from the heavily centralized rule that characterized Uganda's past. But, like I kept saying, the reason the rule of law is being fought for is because the Constitution has not necessarily lived up to the expectations. Technical, when you get back the doctor, kindly, Drake, you let me know. I believe his deliberations were still ongoing. Is he back on? Yes, doctor? Are you there? He's muted. Doctor, whenever you are back and you're able to speak, we still have the floor for you. We haven't yet yielded the floor elsewhere. This is your time, and we are attentively following you as well as those that are online.
Can you hear me?
Yes, we can. We lost you for a few minutes. May you please proceed? We shall pick up from where you stopped. Thank you.
Okay. I think I was now basically trying to see what lies ahead for us. I'm sorry for that. We definitely we shall have to adapt with the new age, the new technology. Many of us are also not in the Gen Z bracket, but we are trying. I had just said that why did the promise of the 1995 Constitution end in an illusion? And how its guardian of the 1995 Constitution of Uganda has been weakened or failed over the past 30 years. The people who are the primary guardians, what was expected of them, citizens? My thinking is citizens should defend their constitution through voting, civic activism, and public pressure. And this cannot relent. And this course of action does not lie. We have seen it. We did witness it with the Arab Spring. We did see it in Egypt. We have just seen
Yeah. Yeah, once again, we're sorry about what's happening. Technical glitches from the other side, but we are on top of it, I hope. We lost the doctor again. He is in his conclusion remarks as to what lies ahead in regards to the Constitution. He's looking at how we can reinstate term and age limits, as we are all aware of the history in the recent past in which we witnessed, especially the Constitution being abrogated, in which the term limits were lifted from 2 terms, which is 5 years, that is 10 years. It was lifted and it was opened, and that of course meant that it was open to the incumbency. And the question that researchers showed was that recently the current Chief Justice made a statement and stated that the extent that he has been almost about the fact to amend however, some other researchers are wondering whether it was actually intentional to use the Constitutional Commission to just come up with a document but leave aspects that shall be amended easily. And that is going to be discussed and identified by our speaker, our speaker on the physical expression here, and those are the questions that I'm going to ask at him. And the doctor was also asking us to wake up from the constitutional slumber. Article 1 of the Constitution reads that power belongs to the people, and our mandate, our role, and our obligation as citizens of the country, regardless of your profession, regardless of your way of life, regardless of any discriminatory aspect, to fight for your rights and the enlightenment of the situation of the Arab Spring and that process of human beings that's around 10 years ago, thereabouts. And that, of course, the clarion call to all of us as citizens, and especially the fact that we are the generation in which we are going to not bring the constitution back to a level of sanity. We're not, of course, going to say it's an easy task. Like we've seen, there's been an erosion of the rights and freedoms that we are aware of. There's been a very big weakness in the erosion of safeguards originally designed to prevent authoritarian consolidation. Ladies and gentlemen, I am only picking from a few aspects that I heard from the doctor. This is not so much of my conversation. We lost him, like I said, and very unfortunately, he is still trying to get back online, of course, and we are supposed to continue in that same vein. Like we were saying, the general weaknesses of the Constitution have been the removal of term limits, in which there was an amendment in 2005, Act number 11 of 2005, in which Article 105, Subarticle 2 was amended, and that was not the only one. Eventually, there was another amendment which that was also, of course, that was challenged in court, but it sailed through, and that has also left the Ugandan constitution in tatters, for which we want to wonder. We are going to make a decision and a judgment call if we can't get the doctor anymore. Technical, is the doctor there? Doctor?
I think I've come back.
All right,
Yes, I'm here.
You're welcome. Yeah, we can hear you. Sorry about what's going on. Please proceed.
Yeah, so I was trying to say that the Constitution, although it has been brutalized, mutilated, and call it, there is still an opportunity, and this opportunity is in ourselves. This opportunity stands with the people. It lies within the framework of civic activism, public pressure. So our moderator has correctly and functionally picked some of the key arguments I'm trying to make. Maybe I'll now just go to some key institutions and see what is expected of them, and then maybe rush to a conclusion since the land doesn't seem to be very kind to me. So apart from the citizens, we also have the judiciary. What was expected? The judiciary is expected to strike down unconstitutional acts and protect rights. One would ask, happy. You've had probably because of the atmosphere that we are largely living in, you've had in murmurs, in whispers, some form of judicial activism. There are instances where the judiciary has acted, and we have applauded. But there are also times that the judiciary has miserably failed us. So what happened? Courts sometimes made bold rulings, e.g., on torture, media freedom, but often deferred to the executive in critical cases, e.g., upholding removal of term limits and age limits. And these are really gray areas, and these are the weakest points of the chain. Political interference, threats, executive control over the judiciary, judicial appointment, compromise, independence, compromise, and all this. So you find that, yes, there are gains. There are some gains in the 30 years within the spectrum of judiciary. But it is quite definite that there's still a lot of work to be done. And the question that goes begging is who stands up to the occasion? Probably we are beginning to see seeds sowed with the arrival of the radical bar. The institution of parliament. What was expected, or what is expected? We expect parliament as the voice of the masses to resist unconstitutional amendments and check the executive. But what happened? In 2005, Parliament voted to remove presidential term limits, reportedly amid bribery scandal. In 2017, it removed presidential age limits after chaotic debate, violence inside Parliament, and heavy executive pressure. When you go back and look at some of the prints, especially newspaper prints of some of these pictures, it's just unbelievable, the presence of all this combat within the principles of Parliament. Now, there's the issue of party loyalty and patronage, which often overrides MPs' constitutional duties. So by and by, you actually begin to wonder whether Parliament in its current form is anything that we can actually lean on or rely on. You look at independent commissions and offices. What was expected? They expected to act as neutral watchdogs. What happened? Electoral Commission widely seen as a partisan, favoring incumbents. Human Rights Commission documents abuses, but lacks the teeth to enforce accountability. Inspectorate of Government has remained more or less a whitewash. They lack resources. There is lack of political will. Over time, appointments of lawyers has eroded independence. I don't have to go to the depth of this. All of it is actually in black and white on the wall. The executive, what was expected? Uphold oath bend the Constitution. What happened? The executive became the chief violator, driving constitutional amendments for personal survival. Presidential power expanded while checks weakened. Security agencies were used to intimidate opponents and suppress them. If you come to the political parties, what do we expect? We expect fair, we expect to see competition. We expect to see them safeguard democratic framework. The ruling party NRM dominates and uses state resources to maintain power. The fusion between the party, I have read or heard some political commentators say that actually once the state is decoupled from the NRM, then probably you're left without the party. The opposition party face harassment, bans on rallies, and legal restrictions. We know that in practice, really, political parties have hardly worked. Regional, what about internal weaknesses, fractionalism, underfunding? All these are manifest in the political party. Regional and international actors, what would we expect? We would think that they would encourage adherence to constitutional democracy. What has happened? We see regional bodies like the AU, ESC, and international partners often prioritize stability and security cooperation over pushing for democratic reform. This reduces external pressure to respect constitutional. So, bottom line, distinguished guests, fellow parents, ladies and gentlemen, the Constitution was designed with multiple guardians, but over 30 years, systematic capture of institutions by the executive, combined with disempowerment and weak external pressure, has left it or left us largely unprotected. In short, 30 years of the 1995 Constitution represents both the promise of democracy and the reality of its erosion. It is a reminder of Uganda's democratic potential, but also of how fragile constitutionalism can be without consistent respect for its principles. I end my presentation, but moderator, if you'll allow, our Center for Constitutional Governance, we promote, we celebrate the Constitution, we work around the Constitution. On the 7th of this month, we have activities to mark a landmark constitutional conference that we are holding. We shall be having a tree planting day and many other activities. And we are doing this also jointly with the Minister of Justice and other stakeholders. All the members of the Law Society and other stakeholders, you are very welcome and always a pleasure. Thank you very much.
All right. Thank you so much, Doctor, for that very intense discussion. And the most important that you have pointed out is the fragility of the Constitution despite 30 years of its existence. Of course, you have also alluded to the fact that the checks and balances envisaged by the framers of the Constitution have been compromised. You have spoken into the different institutions as well as how they have not necessarily delivered what was expected to satisfaction. Spoken about the judiciary that has, of course, tried as much as possible to assert its independence, but it has also showed a reluctance to deliver transformative remedies. We have also seen that, of course, in the case of Dr. Kizza Besigye versus Museveni and the Electoral Commission, that is in the presidential election petition of number 1 of 2001, in which the Supreme Court, led by the Chief Justice, then found widespread electoral irregularities, including ballot stuffing and intimidation, but it declined to annul the election by a 3-2 majority. The same was also passed in 2006, and as well the other institutions like the IGG, the Human Rights Commission that, well, have been established but have not necessarily delivered on their promises. And ladies and gentlemen, we'd like to thank you. Doctor, thank you so much for your time. Thank you for the presentation. We appreciate the time that you've given unto us. We know that you are as well inviting us for the conference. We are very, very humbled to receive the invitation. That invitation came to us as well last week while we were hosting the executive director of CCG, that is Council Advocate Sarah Birete, who was with us on an X Space on Friday discussing general elections, and she also made that clarion call. So thank you for reminding us as well. We shall make effort to be present because at the end of the day, we're all fighting for the same cause. We would like to thank you. There will be a few questions that will be posed unto you because the membership is following as well as the public. We would like to request you to stay online and follow the discussion in as far as the topic is concerned, because you have raised certain issues that I'm very sure the following is going to ask into. Ladies and gentlemen, without further ado, we would like to delve into listening into the next speaker, who is an eminent scholar with over 30 years of experience and has taught at universities of Makerere, myself being one of the beneficiaries in Makerere and Pretoria in South Africa, as well as Juba in South Sudan. His areas of specialty are constitutional law, most important as to why we're here, but again, human rights law, trade law, and economic integration law. He has worked with the Uganda Law Reform Commission as a national legal consultant to review the commercial and related laws, which included the laws on banking, employment, and dispute resolution. That was between 1997 and 1999. This process actually resulted to various reforms of various commercial laws over the past 20 years. He has also acted as the team leader for GTZ, Bank of Uganda Consultancy, to develop a national payment system for Uganda between 2002 and 2003. As he's smiling at his own bio, he also employed as the legal education advisor in South Sudan in 2011 and 2018. He used to move out of the country so much when we were in class, and he would always notify us. He also supported the law school at University of Juba, revised its law curriculum in its entirety, including courses on law of banking, labor law, arbitration law, intellectual property, conflict of laws, and East Africa law. He is vastly knowledgeable in laws of common law countries across the globe and is compiling knowledge management and regulatory compliance systems on laws on banking and finance, corporations, employment, dispute resolution, and the like. Right now, he is the head law consulting and knowledge practice at ALP Advocates. Ladies and gentlemen, with that not very long bio, welcome with me, Dr. Honoria Henry.
Thank you very much for the warm welcome to the ULS House. We've listened to Dr. Tolit give a snapshot of the Constitution. I'm not going to rehearse so many things, but I just want to touch on a number of things. I think a number of people in the room as well as online have had the interactions with me when I was teaching at Makerere. I was at Makerere from 1998 to 2011, and has been rightly pointed out, then I moved from 2011 to about 2018. I was at the University of Juba, And while I was at Makerere, I was teaching constitutional history and constitutional law, among other things. And I'm glad that a good number of the byproducts of my being at Makerere are now in the legal profession, including the radical new bar leadership. Yes, so the Constitution, it's coming to 30 years. Actually, I was doing the calculation, it's actually 15 days. From now, we'll be supposed to have the 30th anniversary of the 1995 Constitution, which was promulgated on 9th October, the Independence Day itself. So the question has been, have we been taking stock? And before, at the start of this event, this was one of the discussions I was having with the ULS leadership, that what have we done to really take stock of the Constitution? Of course, it's been almost 30 years, and we're probably not going to do much justice of how the Constitution has operated or how it has been applied, enforced, interpreted in such a short time. But what I will do is also just touch on a few things that just like the way Dr. Tolit did. For me, the most critical thing is, have we grown the Constitution in a manner that upholds constitutionalism? And as the previous speaker has pointed out, we have sort of dropped the ball along the way. For me, I would call it the constitutional guardrails. You know, like the way you go to a place and there are all kinds of barriers to make sure that nothing falls off. Just imagine you are in a pickup or a truck, and if it didn't have those rails at the side, you'd likely fall off. So those guardrails, what have we done with those in the Constitution? And the reality is that, to a large extent, those guardrails have fallen off. The Constitution remains a very good document. We've sort of amended it and obliterated it in the process. And in the process then diluted what the original idea of what the Constitution should have done. Now, one of the things that normally most constitutions do, and that's in the preamble, is to contextualize the Constitution. Why did we have a new Constitution in 1995 after failed constitutional experiments of 1962 Independence Constitution, the Interim Constitution of 1966, and the 1967 Republican Constitution? Why did we need? Because those constitutions hadn't worked. And those constitutions, if you again history shows us, were the product of the colonialists handing over independence, and then the pigeonhole constitution, which then transformed into the 67 Constitution, which had its major faults. So the idea was that the best way to do a constitution was to gather views of Ugandans. And that was the purpose of the Doki Commission. Did that work from 1988 to 1990, I think 3, almost 5 years. Gathering these opinions, there is a Doki Commission, Constitutional Commission reports. I don't think even anybody ever looks at them. I was one time searching, I found a digital version of them actually, but not the original form in which they appear. I would even get surprised if not many institutions even have copies of that constitution. Now, at the same parallel of that constitution, there was the Justice O'Dare Commission on Inquiry of Violations of Human Rights. That in itself also has implications for how the Bill of Rights is supposed to be looked at. Now, one of the interesting things is that when you go through most of our constitutional decisions or decisions on the Constitution, very few actually provide that context of where did we come from. Very few. And that is sad, because when you look at, for instance, the way the Supreme Court of the US does its, they often have what they call, what is the history and the context. What were the framers thinking at the time they provided such a provision? And that's why, of course, sometimes that's the danger, that they then go to what they call originalism. What was the original intent, the original idea? You've probably heard of that, the concept of originalism in the US, that you can't go beyond what was the original intent in 1776 to apply it to 2025. Of course, the reality also we have to understand, and I think every student of constitutional knows that the Constitution is a living document. It's not supposed to be frozen at the time it was enacted, but should be able to apply to future generations as well. So for instance, now you cannot begin thinking of freedom of expression the way the authors probably thought of it in 1995 or 1994. In this time of digital times, you must then apply freedom of expression to accommodate the realities of the time. So it can't be frozen to newspapers and print media. When you talk about the press, freedom of expression and freedom of the press, we're no longer looking at it. And now that's where the danger arises. Are we allowing laws to curtail that freedom and allowing people to get away with it? We have not been able to test these. I know there have been cases which have been challenged, for instance, the Computer Misuse Act and amendment, especially of 2021 or 22. Now, the question is, how do we appreciate some of these constitutional problems? So I was just saying the context. The closest case that addressed the context of the Constitution is the Chigula case, Susan Chigula. Remember, Susan Chigula was challenging the death penalty, and the arguments which were being presented was that it violated the right to life. And it also constituted cruel, inhuman, and degrading treatment in terms of the time spent in prison, on death row, the method of execution, and all that. Now, one of the things the Constitutional Court in particular did was to look at the Supreme Court, that was the Doki Supreme Court then, was to look at the Doki Commission report. They actually went and looked at the report. And the report found out that two things. Ugandans didn't like disappearances. Ugandans were not happy of them being disappeared, especially during a means time. So they wanted the right to life protected affirmatively. But also Ugandans didn't like being tortured. And so they wanted to make the freedom from torture a non-derogable right. But Ugandans were also aware that people who commit murder needed to be penalized to the extreme extent of their law. And so they allowed that the right to life could be taken away in execution of what? The law, the provision of law that now allows for death penalty. So the court was not willing to say that the death penalty was unconstitutional in light of those views. Now, no other case decision has done that. And that's why, for me in particular, I feel that we have had missed opportunities, especially on the part of the court. That the court has ended up in an era of appeasement, or sometimes what I would call expediency. What's expedient at that point in time than looking at what was the spirit and the letter of the Constitution. Take, for instance, the two critical defining moments of the Constitution, which Dr. Tolit already mentioned: the removal of term limits and the removal of the age limit. I remember when I was teaching law in the early years, I think that was around 99, 2000, and I remember joking to the class of my students then that there was nothing magic about Article 105, sub-Article 2. That just needed a quick majority to remove it. So, in hindsight, the Chief Justice is right. Article 105.2 should have been one of those which should have been guarded by being entrenched, that you needed referendums and all kinds of majorities to actually remove it. But that, for me, is not, again, unfortunately, that was never challenged in court. We challenged the Mabilis challenged the removal of the age limit. But in any case, if you went back to what did the framers of the Constitution want, even for the age limit, I would have thought that maybe the Supreme Court could have gotten bold. The framers of the Constitution wanted transfer of power. They wanted a Uganda where there is routine, periodic change of leadership. But also, I know people think there's nothing magic about 75. There are people who are 75 and they're still mentally acute, they have mental acuity and all that. And so we always refer to our elders that they are the epitome of wisdom. They are the ones who tell all these folklores and stories of the old. But at 75, your mental health, your mental ability is declining. I had the opportunity to be in South Sudan. There's a provision in their penal code that a person who is over 75 years cannot be charged with the offense of murder when he commits an offense. There's a reason for that. He's close to being the same as a person who has committed murder while being insane. Now, if a penal law could recognize that at 75 your mental abilities are declining, why are we thinking that at 75 we should have people being leaders? So but for me the context was that the Constitution should have allowed for us to have generational change of power. 1995 Constitution, it's coming to 30 years, we're going to have the same president as a candidate for the 7th time. I was looking at the figures in the monitor yesterday, and it says the running man. But the running man has never been able to grow his numbers beyond between 4 to 6 million. That tells us the point that Ugandans, we have been growing as a population, and the maximum the president can generate is 4 to 6 million people as voters in his favor. Anyway, I'll leave that for discussion elsewhere. But that just shows you that at some point we need a generational change. I don't know whether that will happen. Again, I don't know whether I will bring back the Constitution to amend it to allow for term limits and age limits. That's another different discussion. But for me, what I'm thinking of and I think Dr. Tolit has mentioned this, have the other organs just given up? The executive can have its free will. I remember now look at the two organs which are supposed to check the executive, the legislature and the judiciary. Have these performed their roles? If you go through the jurisprudence of the courts of Uganda, you could actually break it into two. We're now coming to 30 years. But you would say probably the courts of 1995, from Abuki 1997, all the way maybe to Chigulan 2013, 2014, you could probably stretch it to that's about 15 years. That was courts holding both the legislature and the executive to account for lawmaking, for executive actions. Once we began removing the age limits and all that, because for me, the court's appreciation of the basic structure of the Constitution, I think, was a failure. Because I think they've tried to understand it from that perspective and then failed to look at the context. As I've already mentioned, they should have looked at what did the framers of the Constitution want by providing for term limits and providing for age limits. Now, I don't know how many of you ever looked at the bill that removed the age limit. The bill had what you would call the sweeteners. They allowed the removal of the age limit for the president, but there was a sweetener for the parliamentarians. It was supposed to give them 7 years. Of course, they were thrown under the bus. That particular provision didn't appear in the final in the final amendment. But that shows you that what has happened is that the executive and the president in particular, and I would probably call them his enablers. I'm going to be a bit polite. I don't want to use a much stronger word. Have learned how to manage the two institutions, which are supposed to provide the checks and balances that form the guardrails of the Constitution. But beyond that, I think the Constitution, if we did an analysis of the Constitution, went through its the application of the Constitution, we'd probably find that there is instances where we have actually thrived as a country in terms of certain bills of rights. I'm not saying that everything is lost. The courts have been very strong on human rights. They have been strong in declaring laws unconstitutional. Now, as a country, we're also not very good at enacting laws. We're not very good at replacing laws. The Advocates Act is one. Other countries have replaced the Advocates Act. We have laws, okay, we replaced the Companies Act in 2012, but that also took almost like 15 years. When you mentioned that I was on that reform of commercial law, that's what I was doing. We had 44 laws from companies, employment, banking, even the Sale of Goods and Service and Supply of Services Act 2018. That was done by me in 1999, 97, 99. The National Payments Act, that consultancy we did with the late Dr. Becca Wairama. We did that in 2002, 2003. I remember Bank of Uganda calls me and asks me for the report and the bill that we had drafted with the Honorable Huindi in 2003. Now they're asking me this 15 years later. I told them, you guys, we gave you the floppy disk. That was shows the technology of the time. We gave them a floppy disk plus the physical report. Yeah. But it took the NPA is 2020. The National Payments System Act is 2020. So there are we're slow in enacting laws and reforming laws. And for me, that's the danger, that often then the courts are also subject to applying laws that are archaic. So sometimes you find that a judge is struggling to apply a law because we've never reformed the law. And what has happened is that the judges then defer to the law than the Constitution. Look at the arguments about Trial on Indictments Act and the MCA, particularly Trial on Indictments Act, because those are High Court, in the various bail applications. When was the Trial on Indictments Act the first enacted? If you were probably unborn, probably even your parents were not. This is an admin's decree. It was originally a Trial on Indictments decree, 1971. It actually remained a decree until after the 1995 Constitution. Maybe it changed to a statute, I don't remember. So you are actually asking judges to apply an admin law. And they are tied back to, instead of getting rid of that law and putting in place a new law, which then aligns with the Constitution. So there are so many things that, so again, because the judges are also, and I think this came out through the Ben Kiwanuka memorial, that the idea that the judges have reached a point where they don't even know what to do themselves. They seem more keen to be more executive than the executive. To, as I said, more about appeasement, more experience, that this is something that, for now, if I do this, at least nobody's going to chop off my head from the executive. They're probably afraid of drones and the basements and all that. So I think we need to, as we get to the 30th anniversary of the Constitution, we probably need to take stock. And once we do a proper stock taking, then it's easier for us, and especially the legal profession, to see where we in terms of push reforms. That's going to be very critical, because you can only reform what you can see is failing, but you can only do that once you have done an autopsy of what is failing, what is wrong. And that can only be if we do a systematic review of what the Constitution has been like. Because in the next 10 years, by 2035, we should be thinking, have we made a qualitative leap in the value of constitutionalism? Because the reality is in the last 10 years, it has been in a decline. Nobody thinks that the value of our constitutionalism is really very great. You can see the kind of struggles we are having. The RNB president is in exile. Why? Because he was charged with and is convicted of an offense of, what was the offense again? Contempt of court. But does anybody know what contempt of court is? Yeah? Defying what? Court orders, or being disruptive in court. Was the president ever in any court? Was there a court order? You'll ask that. I've asked that question. If the judge felt that he was being defamed or being abused by the president of the bar, of the law society, he should have opted for a different cause of action, but not contempt of court. So, and I'm asking myself, what is the other judges who are now handling those applications doing? Are they alive? Or did we teach law and it went out of their heads? But then that's again a different matter. But I think for us, we need to do a great analysis of what does the Constitution task of Ugandans. And also, I'm speaking now to the law society, we need to take the leaf of the early law societies during the early years of the Constitution. They were very vigilant in litigating matters. The law society was literally everywhere. So I think that's probably one of the things the law society needs to do. The law society leadership needs to think, can we do more litigation? Because we are the profession that understands the law, understands the Constitution. Can we do what that law society was doing in the 1995 to about maybe like 2015 period? Because I'm trying to look at the last ULS case. I think it was on bail. There was the trial of Besigye both before military court and something like that, the concurrent jurisdiction of the military court and the high court. So that's something that needs to come out. Electoral justice, I will not talk about that. That's something Dr. Tolit mentioned, how the presidential elections have gone, petitions have gone. Independent bodies, again, this is what I was saying, that we need to look at what value have those independent bodies done. For instance, the Inspector General of Government, the ODPP. I know people always think the ODPP is part of the justice, but it's an independent body. The ODPP was the department of the Attorney General's office during the previous constitutions. In this constitution, it's separate. It's supposed to have a separate power as a prosecutorial authority. So what does it do? Is it also being co-opted into the executive proper? Those are questions that would probably need to be looked at. I think I'll just conclude so that we can have questions by pointing out that as we get to the 30th mark of the Constitution, there's need to define what our role as legal profession is going to be. Are we participating in bills that go before Parliament? What input are we providing? I know it's sometimes difficult to do input in every bill, But since it is sent to the Law Society, what are we doing? And also as a society, I hope what I'm thinking of is that one shouldn't just send it to members that give comments. We need to be more interactive than that, because often members are too busy doing so many things that the comments might not come that very visibly. I remember when they pushed the Minister of Internal Affairs was trying to push a forensic evidence bill. I think you people circulated because I taught forensic medicine and the law at the University of Juba, I thought the bill was a lot of hogwash. So I actually commented on it, and they actually withdrew it. They actually withdrew it. I've come up with something a bit better. But that shows that if we take time, that time I was particularly offended by the nature of that bill. But if we take time as a profession, we can actually do better and have a greater input on these bills. I know sometimes we're not given much notice. The UPDF bill amendment bill went from first reading up to third reading in a week. So probably there was no opportunity to to provide the input. But where there's input, we are the learned, we're the ones who should know the law. So let's do that. That's one. Then, as I said, the second, let's be more proactive in providing strategic litigation of constitutional matters. Let's make the Constitution alive. And then let's put effort to actually make sure that our submissions and arguments before the court are going to be well bought. Why I'm saying the law society should lead, because there are too many people. Like now there's a petition that was filed against the UPDF amendment bill. There was one which was filed even before the bill was gazetted. So that one is probably going to be thrown out. Then there's one which has been filed by NUP. It's largely a political petition. It has a whole bunch of people who have been arrested, affidavits, who was charged, who was arrested. But I have a feeling even Eddie Mutwe's affidavit is in there. But so that means there's a need for the law society to lead in constitutional litigation, strategic litigation, as well as to then be the framers of the decision making by the court. Because we know the law, so we should be leading that. I know often the lawyers are engaged by the petitioners, but we can't abdicate this role as the law society to. You should lead at the front. Anybody else joins you or is supportive to this role. And then, as I pointed out in my original discussion, let's think of how do we document, how do we provide a historical reflection or mapping of the Constitution. And I was tasking this of the law side so that the next generation, whether 10 years from now, when we're celebrating the 40th year, we actually have a commentary on the Constitution. Because right now, if you ask me, sometimes when you tell someone, oh, do you know this case, they even scratch their head, when was that decided? Because we don't have. Yeah? I know you could go and Google on Uli, is there a case on bail? They will give you a whole batch of cases. But how have we tracked them? So for instance, when you look at what is it called, Guruka's case? Yeah. Do you know that many people even didn't realize that that was not even the starting point about trial of, yeah. There was the ULS Society case with the Philip, the current Assistant Deputy Attorney General in 2002. Petition is 208 of 2002. There's also a case with about so many UPDF soldiers, which was decided in the Court of Appeal with the lead judgment by, what's her name? She's now in the Supreme Court, which was never appealed. The Attorney General never appealed that decision. But the lead judgment was that trial of civilians in military courts is unconstitutional. Yeah. So there's a lot of history. Yeah. When the continued executions happened, I wrote an article. That's what impressed the Deputy Attorney General to actually file that petition. He went through with it, then at the time, didn't realize Law Society was also filing one. So the point is that there is a lot of case law and the legislative enactments that have given life to the Constitution. Unfortunately, we don't have that kind of documentation. That's what we need to, I think, do. So as we look at the approach 30 years of the Constitution, that's some of the things we should be having at the back of our minds. A tapestry of the Constitution, how has it worked? Because then it helps us to learn where there have been failings and where we can chip in, and then also leading the process of ensuring that the Constitution is actually respected. So I thank you, and we'll wait for questions.
Thank you so much. A round of applause as the doctor walks back. A lot of history, a lot of wisdom, a lot of insights into exactly what the young lawyers, as he said, need to know. We have taken stock of your discussion, but we haven't taken stock of the Constitution. Ladies and gentlemen, we would like to thank you for continuing to be with us. We have heard from a very, very senior citizen in that regard as a constitutional expert, and we have taken a lot of notes, especially the contextualization of the Constitution. That's supposed to be the bedrock for the courts to take into consideration the context, the framers, what was their intention in the first place. We should also consider the Odoki and Oder commissions, which were actually used to speak life into the Constitution. We've taken note of the Susan Chigula case and how some of those rights and some of those freedoms were given birth to. And of course, we are not going to forget the very important word, guardrails. Somebody repeat after me. Repeat after me, guardrails. The guardrails, like that pickup that he said, have fallen off, which means we are next to naked. We can no longer be protected by the Constitution that the framers had intended was going to protect us, which of course takes us to the very interesting penal provision in South Sudan. 75 years and you cannot be convicted for murder because they assume that after 75 you're not mentally capable of making a decision, and that of course now means that our removal of the age limit leaves us bare. Questions for us to think about, and of course we are welcoming question and answer. We have heard from the doctor. We are welcoming question and answer from those that are online and those that are physically present. Please feel free to raise your hand. We have very few minutes for that session. But also, as we were listening in to the doctor, we were joined by His Worship Aisu Nicholas, who is a senior principal magistrate grade 1 at the City Hall, who is here to officiate at the swearing-in ceremony that we earlier on let you know. Doctor continued to add to what Dr. Tolit was talking about, and of course we are looking at aspects in which the guardrails and the checks and balances, like the institutions that were established, like the Parliament and the IGG and the Human Rights Commission and the Electoral Commission, which were supposed to ensure that there is going to be a peaceful transfer of power amongst others. There is going to be protection of rights. There is going to be ease with which people will go about their lives. And unfortunately, we have heard from the doctor that that was never given the importance. And we have also learned, as we realize, that there is always compromise among us human beings. Our honorable MPs were duped. Did you hear that? The sweeteners. 7 years and it was never put in the bill, and then the one that was supposed to enable the president have an extension of his 5 years was the one included. That of course also means to speak to us and ask whether our honorable MPs are actually speaking for us. And somebody, Doctor, asked one question. Why is it that those that are discussing the law are not lawyers, and why aren't the lawyers in Parliament? Well, those are some of the questions that the general public is asking. Doctor, of course, also pointed out positive aspects about the Constitution, which cannot go without saying, because, like I said before, and Dr. Tolit alluded, we are also having aspects in which the human rights have been upheld. There's been declaration of laws unconstitutional, and the problem, of course, with all that is the laxity amongst the courts and the judicial officers, who are mostly trying to be appeasing the general leadership. Of course, we are also imagining that, for those who didn't know, the Trial Indictments Act is a 1971 act, and it was a decree from the Amin government that is supposed to be an indictment unto us, especially the legal profession, but also our elders. Like the doctor said, he was in the Law Reform Commission, and those are some of the things that he has been fighting, and this is exactly the clarion call that he has given unto us, with the blessing that he has given to the Uganda Law Society and our mandate to lead by example and take the fore to make sure that such constitutional amendments come in handy. We received, Doctor, for your information, we received the UPDF amendment bill 1 minute to the time we were expected in Parliament, and we insisted on writing the time received. 11:59 a.m., and we were expected to be in Parliament at midday. So there is, of course, certain lips that we are not going to wash away. Maybe also very important is the clarion call the doctor has put forth, because, of course, as a member of the Uganda Law Society, for whom he has been fighting, we would like to call on lawyers and the general public to join us to lead as the forefront on especially strategic interest litigation cases. Doctor, once again, would like to thank you for this opportunity to be in your presence. Thank you for the wisdom that you've shared. We'd like to pray that the Lord will bless you in all your endeavors, and we want to thank you for opening your door unto us, because without you, we can't do much apart from do the little we can. And such senior citizens of your caliber do not come easy. Thank you once again for your time, and God bless you. Ladies and gentlemen, it is time for question and answer. We were going to ask a few questions. I don't know if the doctor is still on, Dr. Tolit, technical. Do we still have Dr. Tolit? Okay, thank you so much. We have a question in the house. Kindly, there's a microphone here. Please introduce yourself by name, where you're coming from, and shoot to your question. If it's a direct question to anyone, please ask, but if it's general, we shall share them between the two speakers. Thank you so much.
All right. Good afternoon, everyone. I want to first commend Dr. Henry Honoria for being a very brilliant man. He stated a lot of things that have been on our minds. My question is in regards to the Constitution. We have often seen laws being passed. However, we struggle with implementation. So we see different laws in the Constitution. We know what the law states. However, when it comes to real life, it's a completely different scenario. For example, we know what the law states as far as police conduct or UPDF conduct. However, what they do on ground is completely different. Also, I would like to comment on something that was stated earlier, which is in concern to the law evolving. So where the Constitution was originally is not where we are. And I think that is one of the main reasons why it's open for it to change and grow and be amended. Because if we had those same laws that we had back then, if we had them today, things would be extremely different. And last but not least, my question to you is about the judiciary in Uganda. Is it truly independent, especially during a political season as such? We've seen particular instances within political cases. And so we are wondering, when the judiciary is making particular decisions, are they truly independent, or are they affected by our political climate? Thank you so much.
Thank you so much, Shanks. Did you leave your name? There's a question out there. Kindly relate with your name where you're from so as to take a record of who you are. You can also stand up if it's okay, please. Thank
Good
you.
afternoon, everyone.
Good afternoon.
Michael Deng is my name. I work with New Vision. This question goes to Doctor. Doctor, in your perspective, in your view, what have been the major achievements of the 1995 Constitution over the past 3 decades? Secondly, how can the amendment process be made more inclusive, participatory, and transparent in the future? Thank you.
Thank you so much. Thank you, Maggie. Okay.
Good afternoon, ladies and gentlemen.
Good afternoon to you.
My name is Edgar Matthew Karuhanga. I'm from NBS TV. And Doctor, this question goes to you. So what next? With all the challenges you have talked about, I had something called constitutional authoritarianism, something like that. And with a dispensation such as this one, where we see continued fall or downfall of law and the rule of law and implementation of the law, what do we do? Especially if we have also a legislation arm that some people like to call the walking stick of the executive. In such a situation as this, what do we do in order to bring back sanity and legality for the next generations that are yet to come? Thank you, sir.
Thank you so much, Edgar. Doctor, the microphone before you can be activated. Are there any other questions? I hope you can take those ones. Did you take note of them? Please proceed.
Yes, thanks for the questions. I'll go this backwards. So I'll start with the NBS. Okay, I'll start with the NBS question. What next? I know that's a very difficult question, often, especially when you are in a situation where sometimes they say when you are against a wall or a rock and a hard place, what happens next? But I think what I can say, and that's why I was doing that clarion call to the ULS, but I think to many people, you know, one of the things that has happened, and as I've learned by looking at what's happening in the US, the US feels that they are going through their own variation of authoritarianism. But what the average Americans have done is to litigate. Literally, they have flooded the courts. There is not a single day week that not a case is coming out of the courts challenging what's happening from the White House and the secretaries of state, especially those dealing with the education, foreign affairs, interior, and all that. So that's the critical thing. That can we grow that backbone as a legal profession, as civil society, and say this law, no. This particular executive action, no. And then the question then that becomes, will the courts also live up to their responsibility? But our job as citizens is basically to say, this is what the Constitution says, and what you are doing is wrong. And we have an organ where we can take these matters to. I think we can't say, oh, let's rush to take up arms. No, we already have tools, and those tools involve using the courts, using media, maybe to highlight some of these wrongs and some of these constitutional violations. So you have tools that we can use. So I think we shouldn't give up. Let's flood the courts. The other question was on major achievements of the Constitution during the 3 decades. I would probably say the Bill of Rights. And that's why I think that we need to take stock. Between 1997, as I said, from a bookie, even up to now, the recent case of military courts, that's evidence that the Constitution's Bill of Rights are on a very good foundation. That when the judges and the courts apply those bills of rights, they actually uphold them and they actually give life to them. What do they mean? Eh? For instance, if you look at the Uganda Law Society case, which went all the way up to the Supreme Court, Justice Mulenga's decision, where he said bail is applicable across. It doesn't matter where. So even when you're in a military court, you're entitled to bail. That was very instructive. That bail was available to anybody. It doesn't matter which court. The Article 23(6) doesn't specify which courts. It just says you have a right to be granted, to apply and be granted bail. So for me, it's the Bill of Rights. And the courts have strongly upheld Bill of Rights, including even where sometimes the government is saying, but this right is limited. The court have tested it under Article 43(2)(c). Is this limitation in accordance with the demands of what is reasonable in a democratic society? Look at the Chivumbi's case. That was one of the instances of police power under the Police Act. They were challenging a section of the Police Act which required the police to be notified and the police could disband demonstrations and processions. And the judge said, it was a 4-1 decision. The Constitutional Court said, this does not meet the requirements. It's not necessary. Those restrictions are not necessary in a free and democratic society. Because in a typical free and democratic society, what should happen? You want to hold a procession or a demonstration, you tell the police. And what you're telling the police is, can you come and not disband the procession, but can you provide give security for maybe the directions and all that? And also then there'll be, in a democratic society, the requirement then there'll be internal management of the procession by those who are organizing it. And then you can probably demarcate, as happens in other society, country society, you can demarcate where you can want the procession to proceed. You give guide, but you cannot just say, no, we're not giving you the. Incidentally, does anybody know where the origin of the police power over processions and assemblies? And this is why sometimes I get amused. The leaders sometimes say about history, and they think so much about history, but they don't actually look at the history about this. The requirement to seek permission or to notify that you're going to hold a procession actually originates from colonialism. You go back to the laws such as the removal, the police, even the Police Act of Ordinance of 1951 had it. But the reason why the requirement to get permission or permit or order to assemble or to organize it was because the colonialists were not happy about our African rituals. You are marrying, you are celebrating and shouting. You have a harvest, a big bounty harvest, you are arranging a procession. And they felt that this was disrupting their peace. So you went to the commissioner, the district commissioner during the colonial period and said, we are going to have a marriage ceremony. And then they give you a permit that between 10 a.m. and 6 p.m., you will hold your marriage ceremony. That's where it originated from. When we got independence, the political leaders discovered this was the way to deal with the opposition. So that's something you need to understand. And it's not only in Uganda, even all the way. By the time they challenged them in Ghana, Zimbabwe, and which other country, and they struck them down in the 1990s. That was the reason, that was the history. So, Bill of Rights. There are other aspects of the Constitution that have been significant, but it has mainly been the Bill. If you look at the jurisprudence, it has mostly been on the Bill of Rights. Where we have failed, and as this is right, we have failed on other constitutional matters like the term limit, the age limits, some of those things about, we have also tried to strengthen the judiciary, independence of the judiciary, because that's important to the judges themselves. But sometimes I keep wondering, sometimes the judges also forget their own decision. There's a decision the judges ruled in 2013, I think it's Gerard Karuhanga, that the president had no power to appoint the former Chief Justice or justices without recommendation of the Judicial Service Commission. But something happened, but that's a different story. after that decision. And the beneficiaries forgot that they had made this decision. But the judges have been strong on judicial independence. They have condemned the appointment of acting judges, although it's on appeal. But now that's where now I think we need to begin to understand. And I think it becomes a question for how do we ensure that, especially this Attorney General has this habit. Each time the government loses a constitutional petition, he files an appeal and sits on the appeal for the next 5 years. That's even what happened to Gaba Giruka's case. In the process, they were losing judges in the Supreme Court. So the judges couldn't have a quorum. Now that case, the judges whom the court said couldn't be acting judges have now been confirmed. But there's a new batch of acting judges. Now, one of the things which we never understood, Article 92, it's coming up in the petition. I know it's been raised in the petition over the UPDF. Article 92, again, the context has never been analyzed by the court. They should have taken that opportunity in the Palmer decision, because the Palmer decision was intended to, the Palmer Act was intended to get around Kivumbi's case, and the court saw through it, but they didn't analyze the reason why Article 92 is there. Article 92 comes from a history. Again, our history, that's why I think that we will begin, the courts need to be, even as ULS, we need to inform the court why these provisions exist. We need to go to the context. I don't know how many of you remember your constitutional history. When Nadiope was appointed the vice president as the Chabazinga of Busoga, there was a challenge of his appointment as Chabazinga. And that gave to the Agoba something case in 1963. Immediately, Obote's regime passed the Busoga Validation Act to validate that election and get around the decision of the court. When they, again, those who are constitutionalized, remember Ibingira cases. When the court found that the deportation of Ibingira violated the constitution and that the emergency detention regulations were unconstitutional or were illegal, Obote again went and immediately through parliament enacted the Deportation Validation Act, 1966, to get around the decision of the court. The Deportation Validation Act of 1966 was even given constitutional master in the 1967 Constitution. Basically, you couldn't challenge that act even if you wanted. The Constitution protected it. Can you imagine that? The Constitution protecting an act of parliament. So now when you see the executive and the legislature, I don't know whether someone needs to take them through this history, trying to get around decisions of the courts by enacting same laws. I think we need to be worried that they have learned that this is just what happened, and they are thinking, nothing will happen, the courts will not do. And that's why I was saying that if the courts have learned from what they did in the Palmer decision, they should be able to strike down even the Amendment Act of the UPD. But that's now sub judice before the court. The other question was on implementation. I think implementation is more when, is there something that needs to be done, like maybe put in place institutions, put in place mechanisms. That's where I would worry about. But where a situation where you have a law and then the conduct of the relevant government agencies is against that law, I think what we need to do is then challenge those actions before court. Now, unfortunately, the law which should have enabled us to challenge violations of human rights, that the Human Rights Enforcement Act, the regulations which were passed under it were passed wrongly. Each time the matter went to the High Court judges say you can't bring this before us, you have to go to the Constitutional Court. That has been a problem. So we wrote to the Chief Justice, and I think another organization, civil society organization, also wrote complaining to the courts that these regulations these rules need to be redone. And I think right now, because of those letters, once they are going to revisit those regulations. Now, if those regulations and rules are dealt with, that means that any violation of a law that has been enacted to enforce human rights or to govern society, provide law and order, should then be challenged on the basis that there are violations of human rights. There have also been instances which we've seen from anti-corruption court. If you torture someone and you bring up, anti-corruption and in the criminal division, if you torture someone as well, bring them before the courts have vacated the charges because they are relying on the provisions of the Torture Act and Prevention of Torture Act, which says that anybody who has been tortured and is then brought before a court on charges, then those charges, that trial will be vacated. Now that's a positive application of that law. But the problem is sometimes this jurisprudence gets lost, that people don't realize it. Now, if we document this jurisprudence, it's easier immediately to go to court. This person has evidence of torture, like now Eddie Mutwe. His conviction and even trial should be vacated. It shouldn't actually even begin taking place. As a judge, you should be relying on the act, proof of torture. And you see, I don't know whether it's Uganda or in another jurisdiction, I think it's Uganda. You don't need to provide medical evidence of torture. Because chances are that often that evidence is, I think it's a Ugandan decision. It's actually a very recent decision. Yeah. Okay, so that's one of the things we need to look at in terms of legal enforcement. Then free independence of the courts. I've already said that independence of the courts, you can have what's provided in the Constitution, Article 128, from the way you appointed, the tenure that you are appointed for life, and therefore the idea of acting judges didn't make sense. The idea of 5-year terms for industrial court judges didn't make sense. That was struck down. The idea that they are paid from the consolidated fund and not taxed, that makes sense. All those provisions are there, that they will make decisions free from fear or favor. That's there. Now, the question is then, it's not what the Constitution provides as the spirit of judicial independence, is the real lived experience. The judges should, in making decisions, be able to say, I'm going to make this decision without worry or fear that there are going to be reprisals. Now, that's where now we need to see the test. And so when you find decisions where a judge says this person meets all the grounds of bail, meets all the grounds of bail, but let's wait for a trial. Now, there you are seeing the judge aware of what the law is, but very afraid to apply the law. Yeah. So now that's where the lived experience, what are they doing in reality? I think that's what the test should be. Yeah. And so, how we deal with that, I don't know. I know basically lawyers have said they're not going to appear before particular judges. Yeah? Or even, I think a number of lawyers have said they're not going to appear before a particular judge, whether that's a reaction or another. But also, I think we also have remembered that as a judge, as lawyers, you have the right to ask the judge to recuse themselves. I think boycott doesn't make sense. I think it should be ask the judge that we know this is your record, you are not very good at, so you recuse yourself from this matter, let it be. Yeah. Because sometimes when you just say we don't appear, then you are leaving your clients at a loss. I know basically himself says he doesn't want to keep appearing before the court. But I think for me, it's how this impacts on our understanding of our responsibilities. Yeah. As I've said, the fact that you have worried about the pressure from the executive and the legislature shouldn't deter you from being brave to litigate these matters. And the idea is that, I remember when it's called the miniskirt. The Anti-Pornography Act was enacted. And remember, I don't think how many of you remember that story of one of the lawyers who was arrested and thrown into the court cells by the magistrate because she was in a miniskirt. So when we were planning to challenge the law, I told the people who were pushing the petition that call her, let her be a petitioner. And indeed, she became petitioner number 5. So sometimes even some of those lived experiences can be the basis for you to say, no, I need to challenge this law because I've lived the experience of how bad it is. And so I think as we get to the 30 years, let's think. You're a vibrant generation. And these days, AI helps you a lot. You can generate for your draft petition quickly, or at least the framework of it. So you don't have to say, oh, now I have to sit down and think through it. You have a framework that it can quickly generate for you. You build the foundation, feed in the rest of the flesh to the petition and affidavit. So let's be proactive. Thank you.
A big round of applause for the doctor. We thank you so much. I hope we have been answered satisfactorily. And of course, he has left us reflecting on the original intention of the Constitution. I happened to get a copy, a soft copy of the Constitution. And Doctor, what caught my eye was the preamble that reads, "We, the people of Uganda, recalling our history, which has been characterized by political and constitutional instability, recognizing our struggles against the forces of tyranny, oppression, and exploitation, committed to building a better future by establishing a social, economic, and political order through a popular and durable national constitution based on principles of unity, peace, equality, democracy, freedom, social justice, and progress, exercising our sovereign and inalienable right to determine the form of governance for our country and having fully participated in the constitution-making process." And finally, noting that a constituent assembly was established to represent us and to debate the draft constitution prepared by the Uganda Constitutional Commission and to adopt and enact a constitution for Uganda. Do hereby, in and through this Constituent Assembly, solemnly adopt, enact, and give to ourselves and our posterity this Constitution of the Republic of Uganda, this 22nd day of September in the year 1995. And it ends with, "For God and my country." So, Doctor, your answers have left a lot to be desired from here, and we pray that your clarion call, of course, under the auspices of the Uganda Law Society, shall be taken in stride and followed accordingly. We want to thank you once again for the opportunity and for the answers. Ladies and gentlemen, do we still have the doctor? I got some questions for the doctor. Technical, is the doctor on? He's on. Doctor,
yes, I'm
okay, thank you so much. Doctor,
yes, I'm here.
There is a question from one Rehume Muhechi, and it's asking, how has the Bill of Rights shaped Uganda's human rights landscape, and where have gaps emerged between constitutional promises and practice? I'll say the question again. How has the Bill of Rights shaped Uganda's human rights landscape, and where have gaps emerged between constitutional promises and practice? That is from Rehume Mohechi. We thank you for the question, an online question. But also, Doctor, there is another, if you don't mind, to take them together, and then you can delve into them at once before we go into the next agenda item. It is about electoral democracy, and it's coming from Akelo Agnes. Oh, yes, it asks, given repeated electoral disputes What constitutional reforms are necessary to guarantee free, fair, and credible elections in the future? I repeat once again, given repeated electoral disputes, what constitutional reforms are necessary to guarantee free, fair, and credible elections in the future? And the last one comes from Kawombe Titus. And he asks, as a CSO, civil society organization, how much more are you going to fight for the rule of law? Okay, that's a general question. As a CSO, how much more are you going to fight for the rule of law? Doctor, are we together, please?
Yeah, thank you. I hope you're picking me.
Yes, we can hear you loud and clear. Please proceed. Thank you.
Okay, I'll start with making my reflections on the last question as a CSO. I would want to start by saying that oftentimes when we talk about CSOs, there is a very narrow definition to it. And I would like to try and correct that in one way or the other. CSO, in the many jurisdictions I've practiced in, actually includes the non-governmental organizations, the academia, the religious movements as they have come to be known today, and that is both Christian, Muslim, and others. In reflecting on this, I would want to piggyback on the strong call that Dr. Honoria has made, the one on strategic litigation. One country that I am very impressed with, not that they have overcome all their challenges so far, is South Africa. South Africa is one country, other than speaking about the United States of America, that has really managed to push back state authoritarianism through strategic litigation. Now, I really think that law society should take this point very, very, very seriously, because one of the issues that society actually engages in is issue of advocacy. Now, advocacy again is commonly known, and you'll excuse me for this. It probably very simply speaking on behalf, shouting for, and because of that, it has been simplified to the extent that every time you look at advocacy programs, you quickly or often find activities relating to writing policy, activities relating to state government, protests, and not that these are not important. ESG is a very crucial pillar, which is strategic engagement. And why strategic litigation on? We know that the power that enshrined in the same constitution we're talking about, the constitution empowers citizens. The most valuable platform around the question whether this power should become deductible or this power should be endorsed, or questions should be raised and answers given over a given particular social or economic issue, is fortunately the legal framework. So you find that if we can litigate, in instance, litigation is not an end in itself, but it is actually a means to attain a number of freedoms. So just like the good doctor has stated, if law society takes lead in these matters, first of all, one, law society has the pedestal of knowledge, which is very important when you come to policy engagement. And just allow me to deviate a little bit. When you are looking at the platform of policy engagement, there are basically three key components that you need to map out for you to do around any given policy. That's a question of the actor. There are the actors. There is the question of knowledge, and then there is the available spaces. Now that is a whole, paradigm in itself that I cannot discuss here. But just to allude, say, to the point you made, looking at the last amendment on the UPDF, look at the issue of timing. I want to say here, without fear, that that document was also late deliberately. The intention was to defeat or deny the law council opportunity to be able to contribute to that bill. Now, these are the many ways that civic space is being narrowed today. And that practice, by the way, is not only in Europe. So the question is there, how do we read ourselves? So with actualized leaders, be it NGOs engaged in human rights, engaged in health rights, engaged in poverty. Many of them, in their own different ways, are actually doing a lot of work that is generating knowledge. Because you're not going to get to policy discussions without knowledge, because it's about knowledge. But you find that most of our policies are done in what you call a linear manner. It's top down. Government literally thinks for us, plans for us, and executes on our behalf. And I think this needs to be challenged. So, having said that, what is the practice elsewhere? What I seem to observe is that there is now a phenomenon emerging. There is something they are calling democratic pluralism. We know of the old state, quote and unquote, the old stature of the state, that is the legislature, the state, the judiciary. But in many ways, people are beginning to find ways out of this linear process. I know, especially in Latin America now, they're beginning to organize what they call alternative parliaments or community parliament. Because parliament actually debates issues before they begin to think of the laws to pass or the legal frameworks to support, to promote either those issues, or if it is an unexpected dangerous social issue, to see how to deter them. Now, if our parliament, and this also relates to the question of how the Bill of Rights has shaped how we are managing issues as a society and the gaps. So you find that we have a state, because we have said that there is a fusion between state, parliament, and as well the judiciary. And nobody is ashamed to say this anymore. But if that is the case, then do we give up? No. The issue is we need to continue to mount pressure on the state, because we know that this power is delegatory. The Constitution gave one avenue through the election circles. If this is not working, and if the members of parliament that we elect quickly become a sail away, what then do we do? We just cannot sit back and lament. So in Latin America, they are now having what they're calling community parliaments, because the law enables us to associate. continue associating, even if with disruptions. So in these community parliaments, people are now discussing what is pertinent to their immediate communities. Generate that knowledge and then look for the spaces available, either through litigation for you to have a decision that then can be reflected upon by the political powers, or generate knowledge. Again, the good doctor said, it's here in litigation, you're writing laws. But in other advocacy spaces, you could continue writing these policy briefs. You could continue engaging these members of parliament and try to educate them, raise awareness, because many of them, by the way, I'll tell you, you might think that they understand many things. I do a lot of research related to geopolitics and security in the Congo and Southern Sudan. But it amazes you how just a few kilometers across the Strait, Ugandans actually do not know what is actually happening in the Congo. I'll give you an example. For instance, the ADF. You're shocked that in Uganda, you read in the media and they're telling you, we have reduced the numbers to 10, to 6, and counting. But we'll go and look at writings or reports in the Congo. The ADF, which is Uganda's export of terrain, has remained active for almost the last 16 years. Is the most dangerous group out in that field, working day by night. So information itself, knowledge itself, needs to become central to our engagement. I hope I can answer this.
Thank you so much, Doctor. We are grateful for your insights. You've, of course, given unto us a lot of information in reference to South Africa. We appreciate that. Also, the strategic litigation, which should be headed by the Ugandan Law Society, because anyway, we are as well CSO in that regard, and it is important for us to take advocacy as key, and especially because we are a pedestal of knowledge. Thank you so much for that. And that aspect of democratic pluralism, we shall of course intend to engage the CCG further than that, because you are basing on experience, and it is with such wells of knowledge and wisdom that we can prosper in as far as the fight for rule of law is concerned. That alternative parliament is something that, of course, has to be spoken further into. But like I said before, the parliamentarians, our honorable MPs, have disappointed, and we shall not necessarily say all of them, but where there is one or two, they say, show me your friends, and I can tell you who you are. We cannot necessarily point at all the MPs, but there is the majority who are being said to be enabling the sitting government into incumbency. Thank you so much, Doctor. Once again, may we just give him a round of applause, as well as Dr. Honoria, who is here. Is there any other question? We have run out of time, ladies and gentlemen. We would like to go to the next agenda item, and we can ably concur that the Constitution, as has been discussed by these able citizens, whereas very beautiful, can be said to lack a little bit of progress in as far as its implementation is concerned. We are seeing that it's a very strong foundation, but its promises have been undermined by practices that weaken the constitutional order. And the biggest lesson for us to take home as citizens and members of the Ugandan Law Society is to the effect that the Constitution alone, as it is, as a document, cannot guarantee democracy, except its vitality depends on the commitment of the leaders and the citizens alike to uphold its spirit, just like the doctors have given unto us. Ladies and gentlemen, we would like to thank you very much again for being with us, those that are online and continuing to be with us. Doctor, thank you so much for sticking with us. In spite of the challenges of technology, you have stuck with us and you've demystified both the question as well as the different questions that were presented to you. And it is in this regard that we would like to move into the next agenda item. As we had earlier on intimated unto the membership and the following, we would also like to thank the media houses that are in the house, NBS, BEG, and NTV, and all those else that are in the house. We thank you for covering this, and this comes to you every Thursday between 11 to approximately 1 p.m., all factors constant. We continue to bring to you the Radical New Bar live weekly press and public engagement, in which we are here to help aid access to justice by engaging such very invaluable citizens who are dressed with a lot of wisdom that we can never find elsewhere other than in person. Thank you once again. Ladies and gentlemen, last week, Section 15 of the Uganda Law Society Act was put into play. A general meeting was convened. We had it at Imperial Royal Hotel in Kampala, and therein we were able to make a few resolutions, especially, of course, in the leadership of the Governing Council. And one of the resolutions that were made for purposes of this agenda item was that there came a vacancy in membership of council. And in that regard, Section 15 of the Uganda Law Society elections regulations has been put into play, and today we are following up with that resolution to the extent that we are going to put into play Section 15, Regulation 15, C of that regulation, and it reads, the heading is vacancy in membership of council. Regulation 15.2, rather C reads, where for any reason a vacancy occurs, and C, in the position of council member, the council may appoint a paid-up member of the society to replace the vacating member within 1 month of the occurrence of the vacancy. I will read again. In the position of council member, the council may appoint a paid-up member of the society to replace the vacating member within 1 month of the occurrence of the vacancy. But just to give you background to the vacancy that occurred under Regulation 15, Subregulation 2, a person shall cease to be a member of the council if he or she, under F, reads, is removed by a special resolution of members of the society voting at a general meeting. Like I said, is removed by a special resolution of members of the society voting at a general meeting. Like I said, we had a meeting last Wednesday. There is public knowledge. It's taken judicial notice thereof. And today we are going to witness the inclusion of 2 council members in acting capacity in as far as fulfilling and filling those vacancies is concerned. To do that, we are going to be joined by the Members Affairs and Professional Development Department head, that is Doreen Atkunda, who is going to help facilitate that. With us in the house, we also have, like we said, His Worship Aisu Nicholas, who is going to help to aid the same, and in the presence of an available council member who is the governor or the treasurer of the Uganda Law Society, Advocate Arthur Isiko. I would like to invite Miss Doreen Atkunda, who is going to escort me up this side without necessarily taking so much more time. We are going to take the opportunity to invite the individuals who are going to swear in. We have a Quran with us, we have a Bible with us, and would like to take the opportunity to invite his worship up to the podium so as to facilitate this event. Ladies and gentlemen, his worship, Aisu Nicholas. Thank you so much. Thank you so much. We are going to handle this together. We shall simply call upon the individuals without necessarily using any order so as to take oath, as simple as it shall be, and eventually we shall move forth.
Good afternoon, members. Like I have been rightly introduced by my brother here, my name is Aisu Nicholas. I am Senior Principal Magistrate and in charge City Hall Court. I have moved with my colleague. She's called Ayevare Barbara. She's the clerk. My role is very simple, not as difficult as that of a doctor who has presented a paper since morning. I'll go straight to the program. The swearing in for new ULS Council members, and I have here Mr. Rule Alexander, the acting Central Region Representative at the Uganda Law Society Council.
I, Lule Alexander, swear that I will at all times truly and faithfully serve the Uganda Law Society in the office of Central Representative, and that I will observe, support, and uphold the Constitution of the Republic of Uganda, the Uganda Law Society Act, and the regulations therein. So help me God.
Congratulations, Mr. Lule Alexander. Our next member is Mr. Sali Babu, acting secretary of the Uganda of the ULS Council.
I, Sali Babu, affirm that I will at all times truly and faithfully serve the Uganda Law Society in the office of Honorary Secretary, and that I will observe, support, and uphold the Constitution of the Republic of Uganda, the Uganda Law Society Act, and the regulations therein. So help me God.
Congratulations, Mr. Sali Babu. That was my simple role. I congratulate the president and the entire council upon earning another Kisanja of 6 months in office. I wish to congratulate the newly sworn-in members upon formal assuming office as council members for ULS. I thank you for inviting us to preside over this function. I was informed that it's the first of a kind, so it's historical, and I enter into the history books of the Uganda Law Society. I wish you the very best in your time in office. I thank you all for listening to me. Thank you.
Thank you so much. A round of applause for his worship as he leaves the table. Thank you so much once again for officiating at this function. Would like to thank you. Would like to congratulate the new council members. We would like to thank your team, Barbara, for coming together with his worship to join us at this 37th edition. We would like to also move further into allowing the council members who have just been sworn in to offer their acceptance speeches, because it should be heard and it should be on record that they were sworn in and they accepted to follow the oath they have just taken. Without any particular order, I would like to welcome council member representing the Central to give an acceptance speech. Thank you.
Honorable members of the ULS Council, esteemed colleagues, and distinguished guests around. First of all, I do accept the responsibility that has been assigned to me, and I do pledge to keep by the oath I've just taken, to fully represent the members from the Central region and all over the entire country, to serve and fulfill the intentions and what the RNB stands for. Sorry for that. It is the sign of blessing, or the weather is also trying to bang the tables. Like I was saying shortly, time is not. All the members of ULS to achieve what RNB stands for. Thank you, and I look forward for your cooperation.
Yes, Mr. Sally, you're welcome to the podium to give your acceptance speech, and thereafter we shall take
recording pictures. In progress.
Okay. I greet you all in your different capacities. First and foremost, I want to thank the Uganda Law Society leadership, that is the Radical New Bar, for giving me an opportunity to serve as Honorary Secretary in acting capacity. I also want to thank all the members of the Uganda Law Society, those that moved with us, or who have moved with us through this journey, and those who attended the EGM. And I fully commit to serve in my capacity as secretary and to handle my duties diligently in order to fulfill the Constitution of the Republic of Uganda, the Uganda Law Society Act and the regulations thereunder, as per my oath. Thank you all.
Thank you so much once again for the opportunity, and thank you for accepting the responsibility. It comes with a lot, as you've figured out. The Radical New Bar is an action-packed governing council. If you've realized, every week there is one or two things happening, and clearly the wisdom of the leadership under the leadership of Isaac K. Semakade, who is actually watching us. We want to thank you, Senior Council, for your able leadership and your wisdom, and would like to ask that the Lord bless you with the addition that you've just added to the governing council, and pray and believe that God will guide you, especially into these 6 months that was an extension in preparation for the said elections. Ladies and gentlemen, thank you so much once again for bearing with us. We have had 2 agenda items discussed. We've had the Constitution and 30 years thereafter, how it has been of help, and what is the position towards the future, as well as the swearing in. We would like to eventually take pictures of the governing council members that are here, of course, in the presence of the Honorable Treasurer, who is in the building. Would like to request that the 2 individuals come forth with the treasurer, as well as his worship eventually. But first, these 2. Mr. Sally. There is the addition to the governing council. We now ably say that we have an acting secretary, as well as a representative from Central. Thank you so much once again, and Honorable Treasurer, we thank you for your presence. Is that okay? Thank you. Then we're going to request his worship to join them, because it is under his leadership that they have taken oath. Also for posterity, your presence here should not just go with making them swear in. That's okay? Okay. Thank you so much. Thank you for honoring our invite. May God bless you. The 2 gentlemen without the treasurer, so that they can also enter books of history. You remember, no, his worship kindly remain just in between them, like that. You hold, you can lock your hands. You can lock your hands. Is it okay? You can lock your hands like it was. Okay, there we go. Congratulations, council members. May God bless you in your role. Thank you so much. Thank you. You can take your seats. Thank you. Let's give them a round of applause and congratulate the new governing council members, as well as the general governing council, for the able leadership, as well as being added unto. Ladies and gentlemen, I would like to take the honor to invite the governor of Uganda Law Society, and that is the treasurer, who has been with us from the time we began, to give us remarks as well as close this session in order for us to get to the end of the day. Thank you so much.
Thank you so much, MC. Good afternoon, everyone. Let me take this opportunity to thank Your Worship, Mr. Aiso Nicholas. Your Worship, thank you so much for gracing this occasion and ensuring that we have a swift and smooth swearing in of the council members. My task is as simple as giving a vote of thanks. A vote of thanks to our special speakers, without following any special order. Dr. Henry Honorio, thank you so much for sparing time and sharing those insights about the 30-year experience with our Constitution. I believe what you have shared will be very impactful in the lives of so many members who have attended this meeting. quite a number of lessons to pick, because this session has been about picking the lessons. I believe so many of us have picked lessons, and we shall ably put those lessons into practice. I would also like to thank Dr. Tolit Charles. He hasn't been with us physically, but as you all know, one of the principles we stand for is digitalization. And he has been with us digitally. He has shared whatever he has shared digitally. And I believe whatever he has shared will shape the future of this generation. We have quite a number of people that have been present physically in this session. The advocates, thank you so much for physically sparing time and attending this meeting. For those who are online, thank you so much for being with us. We believe that when we meet and share these ideas, we believe that whatever we share can always be of impact to the society. The topic shared is quite interesting, constitutionalism. As you all know, Uganda Law Society stands for rule of law. And the rule of law has its basis in the Constitution of the Republic of Uganda. This is a piece that has been around for close to 30 years. And we have had quite a number of scenarios that have affected the Constitution of this Republic of Uganda. Notable amongst all is the removal of term limits. Removal of term limits has been an issue that has bruised the foundation of this society. The Constitution was very clear, especially the enactors of the Constitution were very clear. When they talked about the issue of term limits, as rightly said by Doctor, they envisioned a situation of transition, peaceful transition. They envisioned a situation of participation. But what we have in the country, or what we experience in the country, is an issue of rape. The Constitution was raped by the people then. But the beauty is that we are heading into an election season. We are heading into a season where we can influence whatever decisions we want to see in the next 5 years. These are situations, these are issues that we can always bring forward to the people who are campaigning for the various positions, be it the president, be it members of parliament, be it members of the local government institutions that we intend to bring into office. So I implore all lawyers out there, I implore all the members out there that this is something we need to re-echo. We need to re-echo this. It should be something that should be the basis of us electing our leaders into the new cycle of 5 years. Of course, not forgetting to thank the members of Uganda Law Society who sat on that historic day, the 17th of September 2025 at Imperial Royal Hotel, where quite a number of resolutions were passed by the members of the society. I think the record has it that more than 1,000 lawyers attended that day, and one of the resolutions that was passed was exactly what we have experienced today, the issue of having giving council the opportunity to come up with the members of council in the acting capacity. And I want to congratulate you, Mr. Alexander. I congratulate you on accepting the service. This is a service, and we believe that your wise leadership will help steer, especially the members in the central region. Of course, I would also like to congratulate my colleague, Council Sali Babu, on his acceptance of the position of secretary in that active role. We also believe that he will bring much on board, and at the end of the day, it will be beneficial to the society. I would also take this opportunity to thank the members who extended the term of council, who deemed it fit that indeed this current council should proceed with the next 6 months so that they can actually achieve what they intended, what they were voted to actually achieve at the end of the day. So let's members who are here clap for the members then who made such a radical decision. Of course, quite a number of fruits are now emerging. Quite a number of fruits are now emerging from that meeting. And one of the fruits that we are experiencing right now is a notice that actually was published today in the New Vision, calling for the annual general meeting. The Vice President of the Uganda Law Society on the 24th day of September 2025 issued a notice. A notice was hereby given that the annual general meeting of the Uganda Law Society will be held on Saturday, the 18th of October, 2025. We shall be having an annual general meeting on the 18th of October, 2025, starting at 9 a.m. at the Imperial Resort Beach Hotel Entebbe. That is next month. Preceded to that, we shall have the ULS pre-AGM conference that will be on Friday, the 17th of October, 2025, starting at 2 p.m., same venue. There is quite a number of business that shall be discussed at that annual general meeting. And one of the businesses to be discussed is the issue to consider and adopt the ULS annual report for the year 2024-2025 of the ULS Executive Committee. Item number 2, there will be a review of the previously deferred books of accounts and appointment of an auditor. The deferred books of accounts for the year 2023 can be accessed on the website of Uganda Law Society. All those who would wish to have an input, who would wish to review, who would wish to view or analyze the books of accounts for the year 2023 can actually go to our website, www.uls.or.ug. You will access the books of accounts for 2023. The third item to be presented at that annual general meeting to be discussed by the members will be the presentation of the management of accounts for the period ended 30th September 2024. For those who remember, we assumed office on almost the 28th of September 2024 from the previous council. So we shall be presenting the books of accounts that we inherited. Those books of accounts were ranging from January to 30th of September 2024. Those books shall be an item of discussion. They will be presented. The fourth item of business that shall be discussed will be the presentation of the management of accounts for the period of October, when we assumed office, to December 2024. That is the previous year. And January to September 2025, this year. We shall make that presentation of the management of accounts for that period. Of course, that is in light of what we stand for, the issue of accountability and transparency when it comes to management of the affairs of Uganda Law Society. Last but not least, on that day, we shall have the election of the ULS nominees to the Judicial Service Commission. This has been something that has been lingering around for quite a number of months. So that will be the day when the curtains shall be closed and we shall have the election of the ULS nominees to the Judicial Service Commission. For those who do not know Judicial Service Commission, it is an entity that actually it is a body that supervises judicial affairs, which include but not limited to appointment of judicial officers. We shall also be having elections for our nominee to the East Africa Law Society for the position of Deputy Secretary, General Representative, Young Lawyers Representative. So meaning on that day, we shall have a Young Lawyers Representative on the East African Law Society being elected. I call upon all the lawyers in Uganda who fall in that category. This is your chance to shine. This is your chance to offer yourself. Don't sit back and lament. This opportunity has availed itself. You should take it up and influence the future that you want to achieve. Then, of course, last but not least, any other business that shall be notified. So whoever has any other business that you would wish us to discuss on that day, please feel free to write to Uganda Law Society. That item shall be included. Please note that on that day, CLE points, the 10 CLE points will be awarded for members who will be in attendance. For the lawyers who will be in attendance on both days, 10 CLE points will be awarded. That means that out of the 20 points that you need for the entire year, on those 2 days, you'll have half of the points that you require for you to renew your practicing certificate for the next year. Of course, it should be noted that attendance for the AGM is limited only the paid up members for the year 2025. So on that note, I encourage all members of Uganda Law Society who have not yet paid up for the year 2025, please pay and come and join the clan or the meeting of the clan of elders. I always say that the annual general meeting is a meeting of the clan of elders of Uganda Law Society. It is the supreme body, more supreme than the executive council of Uganda Law Society, and it makes decisions that shape how the society is governed. So please, all members, pay up so that you can be able to attend and partake in whatever shall be discussed on that day. Members may also submit questions or queries in advance of that meeting. Questions should relate to the business of the meeting and can be submitted by emailing the Secretariat at vp@uls.or.ug by 4:30 p.m. on Monday, 13th of October 2025. So meaning between now and the 13th of October 2025, any member who has any question, who has any query, or who has any item that he wishes to be added on the list of items to be discussed should accordingly email that email, vp@uls.or.ug, before or not later than the 13th of October 2025. So, members, that is the notice to all members of Uganda Law Society to attend the annual general meeting. Of course, going to my department, the Department of Finance, where I serve in the position of Governor, Bank of Uganda Law Society. Yes. In the bid to ensure that there is utmost transparency and accountability of the finances of the society, and also in compliance of the advice given to us by the members at the annual general meeting held on the 17th of September 2025. I accordingly advised, and a notice was issued out. If I may give a brief history, all auditors of the society have been probably chosen by council, meaning council sits and they choose an auditor, and that auditor audits the books of accounts. And I think this has been ongoing since, I think, close now to 10 years. 10 years. And the members of the society have always been denied the chance to engage and have a say in the auditor that shall be responsible for auditing the books of accounts. So this is one of a kind, 10 years ago, and we have issued out a notice. Notice has been put in the New Vision, page, New Vision, I think page 28, yeah, where we are inviting experts in audit services for consultancy services to provide external audit services for Uganda Law Society, and also consultancy services, provide external audit services to the legal aid project of Uganda Law Society. For the members who are here and for the members listening, some time back I made it very clear that with the changes in law, the changes in laws of the country, it was necessary and it was mandatory that we had to separate the books of accounts for the legal aid project. Legal aid project is that body, is an NGO now. You even have an NGO certificate that allows us to operate in that service of giving out free legal services. So we have 2 books of accounts. For legal aid project, this is specifically donor money, where donors come and stand with us to ensure that our members, our brothers and sisters out there in various regions of this country can actually have what we call access to justice. So those books are different, and the books of the society are also different. The books of Uganda Law Society are strictly books that entail the subscription of the members of Uganda Law Society. The money that you pay, the 500,000 that you pay, yeah, is that money. And that is, and it has a specific pool where that money actually goes. So we are calling upon the auditor to ensure that we can have those audited books so that they can audit and we can ably present those books of accounts. So basically what is happening now, by virtue of that notice, we shall receive bids from professionals who will issue consultancy services, and we shall bring that list to the members who will take a decision on who shall be the auditor, and that will be the person who shall audit the books of accounts of the society. So with that said, thank you for attending. I can see the media outlets, NBS, NTV, Mulengela Express. Thank you so much, and all other media agencies. Thank you so much for being with us. You are the fourth estate. You are the people that ensure that our members can actually see and hear what is happening here. We know it is impossible for all the members of Uganda Law Society to physically attend. So that is why we ensure and we make it possible by having such media outlets to ensure that this can actually happen. Big thanks to DM Services who ensure that we are live on air and can easily be seen by each and every one. The members of the Secretariat, thank you so much, MC. Thank you so much for always ensuring that there is a smooth flow of the items of the agenda on each and every RNB. Really appreciate you as the Radical New Bar Council, and may God bless you, as you normally say. May God bless you too. Rule of law, I heard rule of law. Thank you so much for the coordination. And each and everyone, it may be very impossible for me to thank each and everyone, but I want to assure you that we thank you and we notice. And at the right time, as the Governor, Bank of Uganda, will take action. Of course, like I've already said, I thank the panelists for today. Thank you so much for sparing your time and being with us. To His Worship, Nicholas Aisu, Worship, thank you so much for gracing this occasion, the swearing-in occasion. You were, of course, supported by your clerk. We also thank her for taking on that mantle and assisting you in ensuring that we have a fully fledged leadership of Uganda Law Society. Thank you so much for your time. I think we shall be having a group photo as will be directed by the MC. Thank you so much.
A round of applause, ladies and gentlemen, for the Governor, Uganda Law Society, the treasurer, the most perpendicular treasurer who always sorts our finances out. He has promised us something. Let us pray that God will bless him as the secretariat. We would like to we don't close this issue and would like to invite the panelists and those that are at the high table to take a group photo for purposes of record so as to close the day. Of course, it's raining out there. We also have an invitation to share a meal with the people that joined us today. Of course, in exception of the doctor who is online, we shall give him pseudo flowers. Doctor, please receive our pseudo flowers. But the doctor in the house, kindly approach the podium so that we can take a group photo in order to close the day. Ladies and gentlemen, we continue to thank you for being with us, especially those that are in-house physically, those that are with us online. We appreciate your presence. This has been the 37th edition of the Radical Rnblive Press and Public Engagement. We continue to welcome you to join these spaces and look forward to more intriguing aspects of this nature. A group photo with the most perpendicular Dr. Honoria. May you please take the middle, the two of you. Now you're protected by council members. I cannot join. This is now the most iconic picture for the day. The media, we continue thanking you for joining us. You have not given up on us because we also have a lot to offer you. We appreciate your presence. We appreciate your continued support on having us on the online. We thank those that are from DM events. Thank you so much for the work. And the council is much appreciative, as the Governor, Uganda Law Society has intimated. After we take that picture, the Rule of Law Department will join them to have a picture. If there are any staff eventually over there that would like to join, we shall join them. Thank you. So the Rule of Law Department, Ms. Afra, kindly join. Adam. Okay, thank you. One of the cameramen advised me to intimate to the council members who have just come to take an engaging photo. An engaging photo. Please take one with his worship so that it's engaging. You should be saying, hello, how are you? Welcome to the council. One interactive picture. Doctor. Doctor, we can't give up on you. Let's lose our soul. We don't have to read and be in order.